Hi everyone, welcome to Confessions of a Lawyer. I'm Penny Liu from L.I.U Legal. This week we're going to apply relationship property law as promised to real example. Before we do that, let's recap what we talked about last week. So last week we talked about basic rules of relationship property law, and that is 1. Default rule, which is 50-50 equal division. 2. If you want a contract out of the basic rules, which is 50-50 equal division, then you will enter into a contracting out agreement or a relationship property agreement. And 3, for this type of contracting out agreement to be validly executed, you have to be independently legally advised by your lawyers separately, and the lawyers will have to explain everything to you and endorse their signature and stamp onto the relationship property agreement for it to be valid. So those are the 3 points we talked about. Now this week we're actually going to use an example and see how that law actually applies. Before we do that, I just wanted to answer a couple of questions that were left in the comments section by audience of the channel, and that one of the audience asked, when does the 3 years start? Now that is a very good question. Now with a marriage, obviously you get married, there's a start date, there's an end date. End dates we all know, but the start date is pretty simple, the date of marriage. What happens if you are in a de facto relationship? It depends on the factual factors. So it depends on whether there have been financial dependency, whether there are children to the relationship, whether you purchase big assets together, whether you live together, or whether you manifest to the public that you are in an actual relationship of marriage-like. So in any event, any time you could have entered into a de facto relationship, and your 3 years start ticking from then. It is a factual analysis, but it depends on a lot of factors. So say you and your partner decide to move in together. Just be careful of that, because once you move in together, you're living in a marriage-like relationship, bam, your 3 years starts from then. So just be aware of that when we go into the example. Now let's play with an example now. So we've got Joe, our female lead, and Jerome, our male lead. So we've got Joe and Jerome, who's been in a de facto relationship for 3 years before they decided to get married a couple of years ago. This year, their relationship deteriorated, they're no longer talking to each other, they've decided to separate, part ways. And during that 5-year relationship, they've accumulated quite a bit of wealth. So there is a property with a sea view, now worth about $2 million. They've got some savings in the bank, which is worth about $1 million cash. And then they've got some investments in share portfolios that equals value around $1 million. There's some children involved as well, but we can put that aside for now, just talk about the property division. Now, in the absence of a contracting out agreement, when they go to their respective lawyers, the lawyers will have to do the following exercise, which is putting everyone's assets and liability into columns and work out what is 50-50 division, because the default rule applies. Now there's going to be disclosures, proper disclosures from both sides, from both parties. Just make sure there's no hidden agendas and there's no hidden assets that haven't been disclosed to each other before the properties gets divided accordingly. So in Joe and Jerome's situation, they have a property with a registered valuation, which is a must. We must have a registered valuation that shows the property is worth $2 million. Now they had a $200,000 debt, which is now paid down to $100,000, which means the equity is $2 million minus the $100,000 equals 1.9 mil, which is the equity. That is going to be divided equally between the parties. So simple math, divide by 2, which means each party, Joe will get $950,000, Jerome will get $950,000. With our saving, the $1 million cash saving, Jerome's going to get $500,000, Joe's going to get $500,000. With the investment and share portfolio, when they liquidate that into cash, again, $1 million, $500,000 each. So sounds not too bad and sounds like a pretty good division in the absence of relationship property agreement. But let's rewind back to 5 years ago when they decided to buy the Seaview property. The situation is quite different. Jerome was a starting up mechanic, while Jo came from a pretty wealthy family. So she had quite a bit of cash assets from her family trust, made a distribution to her in the sum of $800,000. And Jerome didn't have any money to put into the property with the Seaview. Both of them wanted the property with the Seaview, which was $1 million at the time for the purchase price. So Jo put in her $800,000, and the rest of $200,000 were taken out by them jointly of a loan from ANZ Bank. Now, if you know that background, then obviously Jo had put a lot of her cash into the relationship in the beginning in order for them to have a small debt, relatively small debt, $200,000 debt. And then Jerome worked really hard, Jo worked really hard during the rest of the 4 years, and then they accumulated quite a bit of wealth. So to Jo, maybe that the 50-50 division is not quite fair or reasonable for her. So if she had entered into a contracting out agreement, would the situation be different? Absolutely. So let's think about the situation where they had entered into a contracting out agreement at the time they bought this property. So $1 million property, $800,000 coming from Jo, $200,000 jointly as a loan. Now, Jo's share in the property is essentially 90% of the property because she had put in 80% of the money, and then she's responsible for the remaining 20%, half of that. So 80% plus 10%, half of 20%, 10% equals 90%. So she would want in her contracting out agreement to say that she owns 90% of the property, Jerome owns 10% of the property. In the event of separation, she takes away 90% of the equity, he takes away 10% of the equity if they put the property on sale. Let's just, for the moment, think everything is going to be sold. And then for any other wealth generators such as savings, investments further down the track, it will be 50-50 division. And that's what they agreed in the beginning when they decided to buy this property and how they're going to deal with their relationship property assets. And now, fast forward 5 years, they've separated. They just need to look at the contracting out agreement, look back on it. What Jo is going to get is $2 million minus $100,000. The equity is 1.9 mil. Jo is going to get 90% of that, which is $1,710,000. Jo's going to get another $500,000 from the joint saving, another $500,000 from the investment. Jerome, on the other hand, will get $190,000 from the property, and then $500,000 from the saving, $500,000 from the investments. So you can see the how contracting out agreement actually affect the division of the property at the end of the relationship, given what the parties might think it's a fair result. Now, as you know, at the time parties enter into, Jo and Jerome enter into the contracting out agreement, Jerome's position will need to be explained by his lawyer, who need to advise him what everything means. And he voluntarily signed the contracting out agreement, then it's legally binding on him when they separate 5 years down the track. Now you might think Jerome thinks that may be a little bit unfair for Jerome, and Jerome might want to go to court to contest the contracting out agreement. It is really, really difficult to contest against the what the parties voluntarily entered into in the contracting out agreement, unless there's super unfairness and super unreasonableness that the court think that they need to split everything 50-50. Court's done that before, but it's in extreme situations. So it is very hard for Jerome now, having voluntarily entered into contracting out agreement, to now turn around and say this is not fair to me, because I'm better off 50-50 rule. So you'll see that Jo, by entering into a contracting out agreement, protects her position greatly, and Jerome's position is negotiated because entering into contracting out agreement. So the main thing is, if you want to protect your wealth, your asset from other family members or from your family trust, it is best that you look at contracting out of the 50-50 rule by entering into a contracting hour agreement, so there's no regrets further down the track when you do separate. So that is a very, very quick rundown of how the law applies to an example. And obviously I don't have all the time here to talk about other complexity, including children, including other assets division, but at the very least it will give you the basis on how the law applies to an example. Now next week we're going to have a bit of talk show where I'm going to talk to various professionals within Wellington on how to purchase a business. Please tune in to my YouTube channel, L.I.U Legal, Penny Liu. Thank you.